Why 27th?
Before that, my lord, this.
Let it be 28th.
But admission matter, my lord, this matter, my lord.
Are the pleadings complete?
Everything
Is it for admission hearing?
My lord, it was listed last on 2024, my lord, February. So thereafter not listed, my lord. So
Thereafter not listed, why are you listing it on a hearing day when you are not certain whether the matter can be heard?
Everything is complete, my lord.
No, may be complete. We'll keep it on a motion day. If August is difficult, we'll list it on September.
28.
28. Correct the date. Yes.
I think it's an item number 44 of daily list. In this matter, I have to file one rejoinder affidavit. So
44 on the request of the counsel for the petitioner stands deferred to be listed after 2 weeks.
Please, Your Lordship. Lordship, with the consent of the other side, I'd like to mention item number 31.
31.
Yes. Lordship, here we are yet to file our affidavit, Lordship. Lordship, may
On
kindly grant us 3 weeks.
Request of the council appearing for the Karbi Anglong Autonomous Council, matter stands deferred to be listed after 2 weeks. It is submitted. The consent of the council for the petitioner has been obtained. You are there, petitioner. Mr.
A. Saran.
Mr. A. Saranya, counsel for the petitioner, is present. I go to now. Yes.
consent of the other side, I'd like to mention item number 45 minutes.
45. On the request of the council, appearing for which respondent?
The petitioner, my lord.
You are for the petitioner.
Yes, Lord.
Your name?
P. Bora appearing on behalf of Mr. P. Hazarika.
MSP Bora appearing on behalf of Mr. P. Hazarika submits that the matter be adjourned. He prays for 3 weeks' time. Release this matter again after 3 weeks.
May I present, Lordship? Item number 23, my lord. The petitioner is not going to place this item. So,
Item 23,
Of
it is
admission.
submitted that by the counsel for the petitioner that the petitioner is not desirous of pursuing the matter. Accordingly, the writ petition stands dismissed as not pressed. Interim orders, if any, stands vacated. Pending IAs are also dismissed.
I am for a department.
Mr. SMT Chisti appears for the
Secondary.
secondary.
With the consent of admission. Let me mention item number 24.
24 years.
First, we take this matter after 2 weeks.
The request of the council petitioner matter stands deferred to be listed after 2 weeks.
May I please, Your Lordship? I beg the matter for listing, Lordship. All pending contempt matters.
Contempt matter. 24th
24th.
August.
It is your lordship. Lordship, I beg to mention for urgent listing for matter. WPC 3836
Why?
Lordship, our areas are pending.
Areas are pending. So list 19 August.
Okay, please, Lordship. Lordship, I beg to mention this matter for admission. Matter related to provincialism. Provincialism. Petitioner name are wrongly deferred from the list of the provincialism.
19 August.
I beg to mention item number 52. In this matter, like strike out of the name of the Mr. A. Vyasar and.
So you have to file an application. Have you filed an application before the registry?
No, man.
You file it, then you make a mention. Item
52.
52. 52. Who is appearing now?
My lord, I already hand over to the client. So they engage the senior counsel, DPC, sir. So therefore.
So that you make a mention when the matter is called up, not now.
Wait, I thank you. Happy. The paying for listing of admission matter is 24 material.
24 matter. 19.
How like that? May I please, Your Lordship? Lordship, item number 17 has been complied with, Lordship. May please make.
Item 17.
Yes, we have complied.
The counsel for the petitioner submits that the directions contained in the order dated so and so, passed in WPC so and so, has since been complied with. Do you have a copy of that order?
Yes, Lordship.
You'll furnish a copy of the order.
Yes.
Copy of the order. It's specific of the court. It is kept in the case record. Considering the submissions made, considering the fact that the directions contained are complied with, contempt court does not wish to proceed any further with the contempt petition. Accordingly, contempt petition stands closed. Disposed of, notices if issued, stand recalled.
Oblige.
Item 17,
Yes,
Only
Lordship.
7. And for the
Mr. SMT Chisti for the respondent.
Oblige.
Yes.
Petition is fine for
Where is the agreement?
agreement
Where is the clause, arbitration clause?
at page number 49.
49.
Point number 22.
22.
Yes, Lord.
And where is your notice?
Notice annexure 3, page number 71.
71. Third counsel for the petitioner. There's an application under section 11(6). Issue notice returning in 4 weeks. Steps on the respondents by speed post within 1 week from today. Matter will be relisted after the returnable.
Apply.
Arbitration petition, section 11 of
Agreement.
contract agreement is in.
Where is the arbitration clause?
It's in page 16, Lordship.
16. Now the clause of the arbitration, page 18. Where is your notice?
To Lordship in page 20.
MS P cutlery. P
For Vietnam.
Z cutlery appearing for the writ petitioner, Mr. H. Gupta, learned CBC, enters appearance on behalf of
1 to 5, my lord.
1 to 5. All the respondents.
All the respondents.
Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. It's an application under section 11(6). The respondents may file their objections, if any, released after return of the case.
You oblige, Lordship.
Yes.
My learned friend is supposed to furnish a report. I have just contacted.
At 2. Then let it be on Friday.
Friday, yes, yes.
Friday?
No, Friday. Can it be Thursday or Friday?
Either Friday or Monday.
Make it on Friday, my lord.
Friday. Let the matter be listed on Friday as on a joint request as Mr. Riyad Tawbildar, standing counsel for the higher education, submits the reports required to be placed before the court will be received by him during the course of the day.
Yes.
Released on Friday.
All right.
Hey, please. Lordship, I have received the instruction, the communication. At a port. At a port.
This case relating to area salary of the petitioner with effect from January 2013, February 2015. After that, I am getting continuously.
Heard counsel for parties issued notice returnable 4 weeks. Mr. Chisti.
1, 3,
Counsel
4,
appears for respondent 1, 3,
3,
4.
4, and 6.
1, 3, 4, and 6. Mr. Choliha appears
Yes.
for respondent 2
And 5.
and 5.
Yes.
Since the respondents are represented, notices are waived, extra copy
Oh,
will be
now
furnished
so far.
in a period of 1 week.
SC finance, they need to be reflected in the court list. That's why they have missed it out.
Registry will reflect the name of
Yes,
all
copy,
council, including SC finance.
Applies.
Apply.
Item 4.
Yes.
My lord, here also, my lord, no letter number, no date, no endorsement copy, my lord.
You find out if such a letter is received or not.
Yes.
Mr. M. K. Bora appears for the petitioner, Mr. D. K. Roy appears for the respondent.
1, 2, and
1, 2, and 3. We'll issue notice, better
yes.
to issue notice. Third counsel for parties issue notice, returnable 4 weeks. Mr. D. K. Bora appears for respondent 1, 2, 3.
DK, yes, my DK Roy, my.
D. K. Roy. 1, 2, 3, and 4.
Yes, my lord.
1, 2,
My lord,
3.
there is no secretary for examination.
Whatever 1, 2, 3, and 4.
Yes.
Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. Steps on respondent 5 by speed post within 1 week from today. Respondents will complete their instructions and apprise the court on the next date of listing. Released after returnable date.
Publish.
May it pleases your lordship. Your lordship, director has written the letter, your lordship, to IS inspector.
Must kind of passport matter for time.
Instruction awaited.
Senior is
The counsel for the respondent submits that the instructions are awaited. She prays for further time. Released again after a week. Mr. Bora appears for respondent number 4, MS Fukan for respondent. Calling in later.
Please, Your Lordship. The matter pertains to compassionate appointment. The father of the petitioner, he died in the year 2008, and the petitioner applied within time, 1 year. Now, I have not been informed whether was there any rejection of my case or whether it was placed before the district.
Please get instructions. Mr. Z. Ahmad appears for the car. Red petitioners, MS K. Fukan. Learned counsel appears for higher elementary.
no, your lordship for government.
Appears for the respondent 3.
3 year.
And Mr. Bora, P.K. Bora appears for respondent number 1, 2, 4, and 5. MS Fukan will obtain required instructions. The respondents will obtain required instructions as to the status of the outcome of the SLC meeting, DLC meeting. DLC meeting with regard to consideration of the claims of the writ petitioner. Released after 1 week.
Date may kindly be fixed.
19th August.
Aye.
Lordship, matter pertaining to grade pay enhancement.
Third, counsel for parties issue notice returnable for with MSP Das, APS for
2, 3, and 4.
3 and 4.
I'm
for
finance.
You are for finance. Ms. K. Fukar, APS for finance.
Not financing, Lordship, respondent number 5.
For respondent 5. There's no 5 here.
Felix.
There's no 5 here.
Yes, sorry, Lord. It's done.
Mr. H. Alia, APS for respondent number 1. Relist again after returnable date.
She is appearing, Your Lordship.
Here, MS,
I am Baroya, Lordship.
RM. It will go.
I'm deeply obliged. Extra copy to be added. Extra copy will send it.
Extra copy is furnished. Howard,
Our Lordship, only one request is that the authority may verify.
yes, of course. Heard, the counsel for parties disposed. Covered matter verification for illuminate. First thing I would dispose of. Right. So, what? Parcel. Yeah, he will see. Yes.
Also, the petitioner also, he has been working as a regular principal in Kharaskar Senior Secondary School, Lakshmipur, with effect from 29/4/2020.
So by toss, by toss.
By toss, by toss, because we got lots of 15 months sales, lots of. Beginning the category also, lots of the numbers.
Now, if date of birth is not a criteria, then
Lots.
toss is also not a criteria.
Yes, lots.
Then,
So they should,
so it's an agreement between you and the private respondent.
toss is gone, lots of. Yes, challenge it, then it tells lots of sent back, remanded back to the department, lots of.
So how will they verify? How will they determine? What does the rule say?
We both are lots of PGT. I'm teaching maths and he's teaching English. So lots of if the lots of relevant, lots of qualifying lots of the degree and lots of postgraduate marks are compared, lots of then lots of they can do it lots of, by comparing the marks.
Yes,
of the-
Mr. Doctor, get your instructions here.
So I will have to take instruction because it's a second round of litigation.
No, there are earlier round of litigation also with regard to validity of his BEd degree also.
But there is a private respondent, you'll have
Yes.
to take steps, you'll have to
Yes,
serve
no, yes,
advance copies.
lots.
Heard Mr. S. K. Das, learned counsel for petitioner, Mr. P. Doctor. Counsel appearing for
I am for
secondary education,
secondary.
representing respondent 1, 2, 3, 4. MSK open for respondent 5. Therefore, the issue, the present proceedings is the selection of the regular principal in the Heraj Khat Senior Secondary School, Lokhimpur. So, petitioner was earlier appointed as a regular principal
Is continuing as on that.
and is continuing as on date. Subsequent to litigations between the petitioner and the respondent, the No, but if you are a regular principal,
Lots of,
how are you removed?
lots of,
How are you removed?
lots of, that is why lots of. There should lots
Where
of,
is your order for regular principal?
lots of my annexer 1 lots of. Page number 27 lots. Also without lots of giving me any opportunity lots of without also I am a regular principal also. They should at least also I am entitled to a so-called lots. And in the hearing also, Lordship, I was not called.
No, but this is why the question of your reconsideration came up pursuant to orders of the court.
Yes, Lordship.
Pursuant to order, Lordship.
What is
Because
that order?
initially, Lordship, there are several litigations with regard to validity of the BA degree of the respondent number 4. Lordship, 4 authorities, Lordship, NCT, Vipuria College, and Lordship, state government and the director, Lordship, filed 4 affidavits saying that his BA degree was not valid. Then, Lordship, subsequently, Lordship, the division bench in several other cases, Lordship, held that all BA degrees were, Lordship, made valid, Lordship. That is why, Lordship, his case was also considered to be, his BA was considered to be valid. Now, since his BA degree was considered to be valid, Lordship, now, Lordship, he filed a writ petition. Then, matter was remanded back to the
State Selection Board.
State Selection Board. Initially, Lordship, what got us
Okay.
same numbers. And Lordship, there is a departmental proceeding pending against him also.
Regular principal of the so-and-so school as and as there was a doubt on the validity of the BA degree of the respondent 6. So, in similar matters, arising in matters where similar issues were raised regarding the validity of BA degree, the division bench of this court held that such BA degrees are valid, and as a consequence thereof, the respondent 6 approached this court by filing WPC 2546 of 2025, which came to be disposed of by order dated 2011-2025, whereby the matter was remanded back to be redecided by the State Selection Board. Pursuant thereto, a decision was taken, and the State Selection Board, upon examining the eligibility of the writ petitioner as well as the private respondent, found that both the petitioner and the respondent scored equal marks.
15.
And thereafter, the matter was agreed to be decided by how was it decided?
Lordship, by lottery.
By lottery.
The same day, Lordship.
On the same day. Stop. In the said procedure, the writ petitioner was chosen as the principal again. However, the respondent refused to accept the outcome. Then what happened?
Then Lordship, he filed WBC 2546 and then contempt.
No. After that, there is a fresh selection that was directed.
No. After that, Lordship, after the lottery was conducted, Lordship, the WBC 2546 was filed. Then that matter was remanded again. Now, Lordship, this
Page 28 order was passed.
No. After the degree was considered to be valid,
Lordship.
he came before the court.
Lordship.
By which writ petition?
I appeared in the matter for the private respondent in the other matter. His BA degree was validated by the order of this honor, not in a similar writ petition. But the writ petition he has filed, which was the order was passed in the writ petition, which was challenged in the writ appeal.
What is the number of the writ petition?
Lordship, in page 6, Lordship, paragraph 4, Lordship, I have given all the numbers, Lordship. Yes. Page 6, Lordship, paragraph 4, Lordship.
You are given 2546.
That is the last writ
That is the last writ petition.
I am asking you the first.
3166 of 2000,
3166, Lordship.
2021. 3166
I'll go to 2546, no, 31.
3166.
of 2021. Order is of 5/12/2023.
3166 of 21, order dated 5/12,
5/12/2023.
12/23.
Which was challenged in the read appeal, Lordship. That is read appeal number 9 of 2025, which was once again decided against the petitioner, Lordship, and then they have considered the matter when they have went for the lottery, which was challenged in the subsequent writ petition, which is now giving the number. This honorable court says no, lottery will not be the valid. Yet find out another way to do so, and they have done it.
So, first writ petition, which upheld the validity of the BA degree, and this order was also upheld by the division bench. Thereafter, the matter was reconsidered by the selection board, and upon both the petitioners securing equal marks in order to decide on the outcome, a lottery was proposed and accepted between the parties. Stop in the lottery process, the present petitioner was again chosen as the regular principal. Stop. This came to be challenged by the private respondent by filing subsequent writ petition being WPC 2546 of 25. This writ petition disposed of by order dated 2011-2025, whereby the court directed the authorities to redecide the matter by devising its own method, which should be guided by fairness and transparency, and without drawing of lots, LOTS. So thereafter, the respondent authority decided the matter by choosing the date of birth. Stop. Since the date of birth of the private respondent was earlier, he was sought to be appointed as a principal.
Appointed. On 3rd, he was appointed. The order was passed. I've just submitted in the contempt petition 17.
He was appointed.
And he was removed.
You're on caveat.
I was not on caveat because the order was passed.
Here, are you on caveat?
No, Lordship. I just came because the facts were not replaced with correct.
You are not appearing in the matter.
I may appear because I have instructions to appear if the matter comes up, but I have no wakalatnama. Lordship may record it because the instructions are given over telephone when we came to know this petition was filed.
All right. The orders were passed for appointment private respondent.
3rd.
On 3rd.
Yes, Lordship. I've just submitted the order.
Third Lordship at 9:30. Lordship, I have the copy.
You have not enclosed it.
Lordship, I filed it on Lordship, 3rd Lordship. This order was passed Lordship at 9:30 hours on.
Stop. The present writ petitioner is assailing the decision of the state's level, is assailing the decision passed by communicated by the Director of Secondary Education, as also the consequential order of the appointment of the writ petitioner, private respondent. Stop. Issue notice, considering the issue involved, issue notice is the number of weeks. Mr. P.P. Dotto appears 1, 2, 3, 4. M.S. Fukan for respondent 5. Mr. D. Deca submits that he has instructions to appear on behalf of respondent 5.
6.
6.
5.
Accordingly, since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week from today. Meanwhile, what is the position now?
Lordship, the post of principal is a purely selection post. Senior date of birth.
What is the position?
Lordship, I am holding the.
He has been removed by the order of 3A.
No.
Now he is on leave. And now he is on leave, and the private respondent could not join. Though he went to this college, but he was not allowed because there is no one to take the joining.
Right. So status quo between the parties be maintained till the next returnable date. Returnable 2 weeks.
Also, we'll fix a date.
2 weeks. The
This has come-
matter be listed again on 24th
Yes, Lord. Because
of
this,
August.
This order has come after 5 years of litigation.
Alright,
You are
Right.
looking at further more years,
Lordship, that is why I'm praying for a date.
24th August.
Highly
alright.
obliged.
Kindly take the matter on Friday, my lord.
The request of the council of the parties that have been listed on. Let it come on Monday.
Yes.
Monday. Supply.
Here, here proposal for arrear salary of rupees 57,05,606 has been placed has been submitted for fourth of account budget during 2026. But due to communication of the communication from the finance department, the secretary has written to the director to submit the fresh proposal citing the budget provision as per new budget for financial year 2026-2027 under approved head of account. This is my instruction. So
So
while the
what-
process is going on here, madam.
How many more years will you require?
And due to budget allocation, my lord, so sometimes it is required. Already, my lord, it is a proposal has been sent for the release of 57 lakhs 5,600.
Yes. The counsel for the respondent. Mr. Soikia, you are appearing?
Yes, madam, I'm there. They are not complying with the judgment of the Supreme Court for so
Then-
many years together.
They have shown some communication where the proposal is already forwarded. Mr. U. Sharma, learned counsel, appearing for the respondent, submits that the proposal has been forwarded. Give us a copy.
Yes, ma'am.
One thing is that they are playing the football from this table to that table. And now they are again asking for fresh proposal. Their mother fresh proposal word has been used for several times. Last time on,
As
I
per
have
communication.
I
with
have
the
brought,
finance
the
department.
number of communication, I received a copy from them, only fresh proposal, fresh proposal. What does it mean by fresh proposal? The last sentence, in this connection, you are requested to submit a fresh proposal.
Yes, what is the meaning of that? Why fresh proposal is required?
My lord, as per communication of the finance department, my lord.
We call for the finance council, who's there?
finance.
Yes, Mr. Cholia. Please get instructions on this communication. Why fresh proposal is required, citing budget provision?
Maybe perhaps the earlier had expired, lordship.
Please get
Yes,
instructions.
yes.
Let him obtain instructions, Mr. Sokia.
My lord, my humble prayer, my lord, let it be a final one.
No, we are asking the finance department to get instructions, what is the meaning of this and what steps are to be taken.
Yes.
So that there is some clarity,
My
so
lord.
that we can issue specific directions.
My lord, that will do.
Mr. Ram Soikia, senior advocate, assisted by Vinod Vaspur, for the petitioners. Mr. U. Sharma appears for the
Respondent.
all the respondents.
Yes.
All the respondents. So Mr. Sharma has placed before the court a communication dated 4/8/2026 issued from the Secretary, Department of School Education, to the Director, requesting for fresh proposal citing budget provision as per the new budget for the financial year 2026-27 under the appropriate head of account. Stop. There is no clarity in the communication as to what happened to the earlier proposals sent by the department. Stop. Consequently, the court has requested Mr. H. Alia, Standing Counsel Finance, to assist the court by obtaining the required instructions as to the steps required to be undertaken by the department in this regard.
Sure, I'll try to bring forward the communication that has been done.
Yes. Release this matter again after 2 weeks.
Omelette. Omelette.
SLP,
The SLP is already been disposed of, my lord, and after that, the government of Assam regularized the 65 numbers music teacher, my lord.
where is the order of the Supreme Court?
I have collected from.
It is here. No, this is for granting some time.
Right, on last occasion, this is for granting some time, and meantime that Supreme Court has
What is the direction of the Supreme Court?
some there. After the single. Seven, six was passed in contempt this matter. All analogous contempt cases.
The judgment of the division bench would be necessary because there are some references made here. Yes, respondent, you're not aware.
I'm not aware, your lordship, and moreover, your lordship, I need to obtain this instruction, your lordship, pertaining to this order.
You take the citation here of the judgment, take it out,
Yes.
get your instructions. It is submitted by the counsel for the petitioner that the SLP, which was pending, came to be disposed of by judgment and order dated 18th November 2025. Whereby the appeals preferred by the appellants therein were allowed. The judgment impugned stood modified by setting aside paragraph 194 thereof. And a writ of mandamus was issued to the state authorities concerned in terms of prayer 4, the writ petition. The final direction was issued to the state authorities to complete the consequential actions within a maximum period of 3 months from the date of the order. And provincialization was directed to take effect with effect from 1/1/2013. Stop. Vera, the state council submits that she would like to complete her instruction in this matter. Prays for 2 weeks' time. Released on after 2 weeks on 21st August.
Deeply obsessed. Okay, go ahead.
Happy. Here in this content case, Lordship, what has happened? The petitioner retired in the year 2021. There is a direction of this honorable court in the year 2023 for releasing the pension and pensionary benefits forthwith. But for last 5 years, no action has been taken, Lordship. I have annexed certain papers to show that the contemners deliberately delaying the matter for releasing the pension and the pension. For last 5 years.
Where is the order of the court?
Yes, Lordship. It is at page number 15, Lordship. The contempt petition. Paragraph number 11. Since the Director of Higher Education Assam, by the order dated 6/2/2023, has already approved the service of the petitioner with effect from 3/10/1988 to 6/3/2009 as lecturer in the Department of English in Said Kasar College, Silchar. The respondents in the Assam University as well as the Accountant General Assam shall do the needful for payment of pension and other pensionary benefits to the petitioner forthwith, considering the fact that the petitioner retired from service on 31/12/2021. Now, in the year 2022, Lordship, in this same contempt petition I've annexed, there's a document, this is the annexation number 2. If your Lordship kindly peruse, on 16/11/2022, page number 17, Lordship. There was a communication from the senior accounts officer to the Commissioner Secretary, Government of Assam Higher Education. I'm just reading that particular relevant paragraph, Lordship. With reference to the subject mentioned above, I am to state that the pension case in respect of Dr. Ramaprasad Biswas, retired reader of Assam University, has not yet been received by this office. As this office has been implemented as one of the respondents of the aforesaid petition, it is therefore requested to forward the pension case with all relevant documents in complete shape at an earliest to this office for prompt finalization of this case. That was in the year 2022. Now, if your Lordship kindly peruse the affidavit in reply that has been filed by the petitioner, in that particular affidavit in reply, if your Lordship kindly see page number 45, what this contemptor has done, the concerned DHE, without signing all the relevant papers that was sent to the accounts officer. So it has been returned back. After 4 years, that action has been taken. Lordship kindly peruse page number 45, annexure X1. It's a communication from the senior accounts officer, the deputy secretary. Page number 45. 45. That is on 15/6/2026. After 4 years. With reference to your letter number dated such and such on the subject cited above, I am to state that the pension case has been submitted to sanction of pro rata pension before attaining the age of superannuation as per NSPR 1969 Part 2 Part 3. Further, whether his technical resignation is accepted, this is not clear to this office, which may be confirmed along with original service book, challan copy of CPF refund, and other supporting documents related to superannuation pension, which should be duly signed and sealed by the head of the department. In view of the above, I have no other way but to return here with the pension case in respect of Sridhar Prasad ex-lecturer. So it has been returned back in the year 2026. For last 4 years, the petitioner is striving for getting his pension. Even the contempt petition is pending, and there are several communication. If your Lordship kindly see the next page, page number 46, it is the communication from the Registrar Assam University to concern Deputy Secretary, Government of Assam Higher Education, for sending all necessary papers for releasing the consolidated pension and pension. There's a clear direction of this honorable court that has been flouted by the contenders, and for deliberate reasons and for cause undue harassment to the petitioner Lordship, no action has been taken. For last 5 years, the petitioner is without pension and pension. Contenders are answerable to the default.
Yes.
Lordship, we have filed one affidavit, additional affidavit, starts from page 30. And regarding my Lordship friends mentioned that submission that we have not forwarded the documents. That Lordship, AG Lordship, accountant,
we have already forwarded. And for Lordship, we have regularized his period which he served under Assam government. Thereafter, Lordship, after regularizing Lordship to receive the pro rata pension, he is entitled for pro rata pension from government side. For receiving the permanent absorption from the university is required, and which was not forwarded to us till 26.
You are
That is-
for the accountant general.
No, I am for the
Higher education.
response number 4, Director of Higher Education. So we have done our part also in terms of the order also, and we have forwarded it to paragraph 7, Lordship, paragraph 7 of this, Lordship, the instruction, the updated original service book. Updated service book has been received from Kasar College, and as per the direction of the government has been forwarded directly to the accountant general.
Who's for accountant general?
Party.
Accountant general is not there in the contempt petition.
Why?
Because first of all, DHA has to finish off all the jobs, Lordship.
They
Lordship,
claims to have done it.
No, X1, the document that I am just placing before this honorable court, page number 45, they have returned all the papers. Now, in a piecemeal manner, for last 22 to 26, for last 4 years, they have not done anything. And there was a
Lordship may peruse the direction of the court.
specific
It was the
direction
direction.
of this honorable court to release the pension forthwith. Now, if the DHA has not sent all the papers in a proper way, then how the accountant general of the Assam University can release the pension? Now, it is to be initiated from the side of the DHA and the commissioner.
They
secretary.
say they have forwarded all this to
Yes.
accountant general.
Lordship, kindly peruse this 15/6/2026, the last
7.
letter.
July, I have sent.
Recently, they have done it.
Hmm.
Very recently. And they were supposed to do it in the year 2023. Now they are doing it in the year 2026, after last 3 years. So there is deliberate laches on the part of the
No,
contempt.
but if we put them into civil prison, who's going to release your?
No, I'm not
pension?
on that, Lordship. I'm
Yes.
just trying to draw the attention of this honorable court with regard to the laches
give
and
us-
negligence.
You tell us why you not arrest the accountant general? They were a party before the court.
No, Lordship.
And direction is to
No,
accountant general.
No, Lordship, let me say, Lordship, here in this case, accountant general, the role of the accountant general would come into play only when the other actions have been taken by the other contenders. They have not done it.
Have you seen a copy of this letter?
No, that has not been supplied to me.
It is communicated.
Recently, it has been communicated after filing my affidavit in reply. The copy that I have received, that they have returned the entire papers. In a piecemeal manner, they are doing all these things for last 3 years. It shows the this casual approach and the contemptuous approach on the part of the contemptuous function. Because the forthwith, the direction is there on the part of this honorable court. Release the pension forthwith.
Where is the direction of the court in terms of
Yes,
doing
Lordship.
it in a time-bound manner?
Forthwith. We can define that forthwith. If they are taking, if they are interpreting that forthwith as 3 years, 4 years, then I have nothing to say, Lordship.
Where is
Because-
that direction again?
Yes, Lordship. Page number 15, Lordship.
Direction may be perused.
Page number 16.
15 onwards.
15 onwards, the last paragraph. Since the Director of Higher Education Assam, by the order dated 6/2023, has already approved the service of the petitioner with effect from 3/10/1988 to 6/3/2009 as lecturer in the Department of English in the State Kachar College, Silchar. The respondents in the Assam University as well as the Accountant General Assam shall do the needful for payment of pension and other pensionary benefits to the petitioner forthwith, considering the fact that the petitioner retired for service on 31/12.
Direction is to the Assam University and the accountant.
Exactly, Lordship. That is what I'm submitting. The direction was to the Assam University and to the Accountant General, but the initial documents which are to be sent by the concerned DHE, that was never been sent. And I have annexed all the relevant papers to show that by going through the technicalities of this particular order, they're dealing the entire matter, saying that we have no responsibility. Direction was given to the Accountant General and the Assam University. They cannot take the plea like that, Lordship. If you are not sending all the papers, in spite of several communications, several letters from the side of the other.
Now let us find out from the accountant general. Who is
Yes,
the
yes.
accountant general? Any counsel for accountant general? Why have you not arranged the accountant general? as
Lordship, at
party?
that point of time, there was no letters on the part of the Accountant General. That's why I can arrange.
We are not inviting you to do that. We, as a council, we are only asking you when accountant general was a party in the writ petition.
Yes, Lordship.
And when there is a specific direction given to also accountant general, you have chosen not to array accountant general as a party. It's a choice you have made. We are only asking you.
No.
We are not directing you to array accountant
I'm
general
not
as a
on that,
party.
Lordship.
It is your choice.
My limited understanding was that, Lordship, at that
Very
point of
well,
time.
your understanding we accept.
Lordship,
But
kindly
now
fix
the
it.
matter is
Lordship,
before the
kindly fix it.
accountant general.
Lordship, kindly
Council.
fix it to. I will just inform the concerned
He
council.
is here already. please get instructions on this communication where the updated original service book is stated to have been forwarded to the accountant general. Where is that communication, Mr. Tovilkar?
That communication I have not been furnished.
You get it and supply it to the accountant general council.
Accountant general, we have supplied, the number is there, Lordship, he can get it.
All right.
Every
And
number.
one copy to me.
When can you get the instructions?
Lordship, after 10 days, Lordship.
Mr. SP
I
Chaudhary,
want a copy of the case also, Lordship. But I want it later, Lordship.
Mr. SP Chaudhary, Learned Counsel, appears for the petitioner. Mr. Zia Tobildar appears for higher education.
Respondent number 4.
Respondent 4 and MS so appears for respondent 5 and 6 as we have for respondent number 2. The contempt petition is directed against the respondents for willful disobedience of the directions contained in the order dated 16/2/2023, passed in WBC 4301 of 2022. By the said order, the following directions were issued. There are 11 of Red Stack 11, 12, 13. There are the counsel for the petitioner has strenuously urged before the court that despite there being a specific direction by the court, the relevant papers, although received from the relevant papers, were not forwarded by the Higher Education Department to the Accountant General's office. Several pleadings were filed by the parties. Updating their status in respect of the directions contained, the order dated so and so. Stop. Today, when the matter is called up, Mr. Tobildar has placed before the court a communication dated 4/8/2026, whereby his instructions have been received by the Learned Standing Council to the effect, inter alia, that the updated original service book has been received from Kachar College and as per the direction of the government has been forwarded directly to the office of the Accountant Generals within bracket ANE, Assam, ID, this office letter number so and so dated 9/7/2026. The Standing Council for Higher Education therefore submits that so far as the higher education is concerned, they have completed they have sent the relevant papers in to the Accountant General's office, and therefore the matter is now presently before the Accountant General to release the pension. So, the Accountant General, although was a party respondent in WPC number so and so, has not been arrayed as a party in the present contempt petition. So consequently, the court has requested Mr. R.K. Talukdar, who is the Standing Counsel of the Accountant General, to apprise the court of the status of the papers pertaining to the pro rata pension, release of pro rata pension of the writ petitioner. Stop. The Learned Standing Council will apprise the court on the as to whether the papers original service book of the writ petitioner as received from Kachar College stated to have been forwarded to the office of the Accountant General has been received, and if so, what steps the office of the Accountant Generals have taken thereon. Let this matter be listed again after 2 weeks. The Learned Counsel for the Accountant General will apprise the court of this matter. The registry will reflect the name of the Standing Council Accountant General in the course list. Released again on 24th of August.
It's a part of the record. And that are the-
Copy of the communication placed before the court is kept on the part of the record.
Yes, yes. All right. All right.
But in this case, Malab,
Hmm?
in this case, finance department has asked to take some approval. Only file is in the process. Only thing is that the date has been wrongly recorded, Malab, in our communication.
6/2026. Finance for concurrent.
Where is the direction of the court?
Direction lordship, find at page number 27.
27.
27. Of the conclusions as listed here in the following directions are being issued. Director of Elementary Education Assam, on view of the determination has made in above that the petitioner is services provided as is protected. Now takes the place of the petitioner before the SLSC for scrutiny of the service particulars. And the Director of Elementary Education Assam, while placing the case of the petitioner hearing before the SLSC, shall intimate the committee that the petitioner is working in the said school as a teacher from so and so, and he admittedly is teaching the subject of social studies in the said school, and in terms of the provisions of section 311 of the Act of 2017, he is eligible to get services provincial in the said school. The state level scrutiny committee, the case of the petitioner being placed before me, shall proceed to scrutinize the service particulars of the petitioner in the light of the determinations made in this order by this court, and thereafter proceed to this recommendation. The Director of Secondary Education Assumption, on receipt of the recommendation in respect of the petition from the SLSC, proceed to further the matter. In the event said recommendation is in favor of the petitioner, proceed to provincialize the service of the petitioner after following the procedure as maintained under the Act of 2017. In the event the petitioner is found to be eligible for provincialization of the services, such provincialization in this case shall be so effected in effect from so and so. 29, last paragraph, the exercise was directed to be completed within a period of 120 days.
Here, my lord, SLSC already recommended the name of the petitioner. The thing is that this is pending for the finance department. Some approval is seeking by the finance department. For that reason, file has been moving in the department.
But the instruction on 3/6/2026 of the
If it is before the finance, what can be done? All these matters are, see, there is a direction by the court to comply within a particular time-bound period. If you cannot comply, you come before the court, pray for extension of time. You do neither. You sit over and then put the blame, it is in this department, that department. You are testing the patience of the court. Every matter, it is the court who has to initiate the implementation of the orders. Why is this happening?
Well, here we have.
This is before the finance department. Is it the end of the job of the director? The direction is to the director. Let the director find out what is going on and why this matter is pending before the finance.
Some 10 days time may be granted. I will bring up to the list.
No, once we send them to civil prison, they'll have enough time to find out. Every matter, the directions are flouted merrily. Every matter, every contempt matter, if I pick up, there is there's utter disregard to the time frame given by the court. If you can't do it, it was disposed of in the presence of standing councils. Why are the standing councils not available to point out before the court it can't be done? If you can't do it, you pray for extension of time. You are in contempt. We'll issue notice of contempt. You get instructions within 1 week or we are issuing notice. The council appearing for the secondary education will apprise the court within 1 week on the status of the compliance with regard to the directions of the court's order. Elementary education.
Obliged.
Released after 1 week. 21st.
Obliged.
Lordship, the order is not yet complied, Lordship, or we don't have the information.
Mr.
B. Bhattacharya on behalf of
B. Bhattacharya appears on behalf of the petitioner and submits that the directions contained in the order dated so and so, passed in WPC so and so, has since been complied with. Therefore, the content that the petitioner does not wish to proceed the contempt petition any further. Accordingly, the position on facts is not disputed by the counsel for the respondent. Taking into consideration the submissions made, the contempt petition stands closed. Disposed, notices is issued, stand recalled. MSK Fukan for respondent 3, Mr. SMT Chisti for 1 and 4, Mr. Bora for 2, minor 2. Obliged.
In this matter, we have filed the review petition, my lord, and already they have appeared here, my lord.
Lordship, the Honorable Supreme Court states that, Lordship, if there is a contempt proceeding is there is a no excuse for filing a review petition for non-compliance of binding order, and with administrative hurdles cannot justify the contempt, Lordship.
Well, yes, process is going on, but he has not be eligible to hold the post
Oh,
of.
but if we proceed in the contempt petition, and if the order is ultimately reviewed, what will happen to the contempt petition? There is a review filed against the contempt.
Yes, Lordship.
Are you appearing in the matter?
Yes, Lordship.
So, if the review petition is allowed, the order for non-compliance of which you are filing the contempt gets reviewed. What happens to the contempt petition? What is the stage of the review petition?
They have already appeared, my lord. We have this already is.
Then you press for dismissal of the review petition. It is submitted to the court that a review petition is directed against the order dated 22/1/2025, passed in WPC 3272 of 2024. Being review petition number
86/2026.
86/26, which is presently pending disposal. Stop. Counsel for the petitioner has also entered appearance before the court in the proceedings. Stop. Release this matter again after 4 weeks. The parties before the court will apprise as to the status of any orders being passed on the review petition.
Deeply appreciated.
Item 16 of the here in similar cases, we have filed an appeal. Initially, there was a stay. I think those appeals were dismissed. Now, all these cases are now being taken together. Lordship for his compliance. Lordship may kindly give it 1 week time, Lordship, to get the final instruction.
From so many occasions took time regarding directions, they get.
Because initially there was a stay by the Honorable Division Bench.
When was it vacated? When was it dismissed?
It was dismissed in the last month, Lordship.
Last month.
Yes, date I have forgotten, Lordship, but it is all the similar cases are there, Lordship. All the cases have been taken together, Lordship. Only a week time with Lordship, kindly.
Mr. F.U. Bhuya, yes, anything? Submit, Mr. Bhuya.
As the last chance, maybe their content are not taking seriously for compliance to order. Chief professors took time for compliance.
Yes, we'll have to send a few officers to civil prison.
Yes, I have communicated that Lordship. I have already.
No, you communicate and you highlight the
Yes, I
time
have
frame
stated-
given
I-
by the
yes,
courts.
I have stated.
That once an order is passed, it requires compliance unless appeal or review. Mr. F.U. Bormia, learned counsel appearing for the petitioner. And Mr. S.M.T. Chisti appears for respondent.
Sole respondent.
Sole respondent. Mr. Chisti submits that similar issues were earlier pending before a division bench in this court. Do you have the number?
Exactly. Right now, I don't. I'll provide. Losime, can you give me a time, 1 week time to get a final instruction?
Which ultimately came to be dismissed.
Dismissed.
And now the government is taking, the government is seized of the matter in which issues
And provincialization of services.
regarding provincialization of services are being undertaken, are being considered. He submits that a week's time be given to him to apprise the court on the status of the compliance of the directions of the court's order by the direct order dated so and so, passed in the so and so. Released after 1 week, based on 21st August. Yes,
Lordship, 1 week time will be granted to take steps, Lordship.
counsel for the petitioner prays for and is granted 1 week's time to take steps of his own respondent. Released after 1 week.
Oblige, Lordship.
Made. But office note says not service report upon contempt number 1 and 2 is awaited.
Do you want to take fresh steps or await?
Since it is awaited,
Office note dated 8/3/8/26 reflects AD card or unserved notice on behalf of respondent 1 and 2 are awaited. Release this matter again after 2 weeks. Mr. M.U. Mondal appears for the petitioner.
this gentleman is suffering from illness. So we have filed a IA for current salary. At
For,
least for current salary.
this is the contempt
Yes,
proceeding.
this is the contempt.
So it's only for compliance of the directions contained.
That's
Beyond that,
in the meantime, if current salary is paid, that will.
but beyond that, how can we direct anything? What is there?
Oblige.
Please, your Lordship. Lordship, in item number 40, actually, I said it is not compliant, Lordship. It is wrongly communicated, Lordship. Not compliant, Lordship.
Why do you make submissions, irresponsible submissions like this?
And I also could not hear what Lordship is saying. When I heard in the live streaming, generally, I could.
Mic is on, you didn't hear me.
No, Lordship, I had some difficulty.
Item number?
14, Lordship.
Item 14 to be called up at 2 p.m. again. Be present at 2 p.m. Yes. Service complete. As per office note 25/5/26, service respect of respondent 456 is complete. Anyone appearing? For? Mr.
Yes, not.
S. Nath appears for respondent number 4.
For respondent number 1, 2, and 3.
Mr. H. Burwa for respondent 1, 2, and 3. However, none appears for respondent number 5 and 6. In spite of service being complete as reflected in the office note. Would you like to take Dusty? No. Release this matter again after 2 weeks. 2 weeks for admission.
Okay.
Yes.
May I please, also, my lord, we have preferred this interlocutory application, for, change of the array of respondents. What has happened? We did implement the director of secondary as well as the school education secretary, as the secondary department. My lord, these categories of institution is now being, administered by the elementary education department. So therefore, my lord, we have made an interlocutory application with the prayer for change of respondent number 1 and 2 from secondary to elementary. I have made a specific prayer.
Your prayer is for
Mad.
implement of secretary,
Mad.
Government of Assam, Department of School Education,
Mad.
and Director of Elementary Education.
Assam. It should be the elementary department. Both.
Yes, no objection.
No.
Third, Mr. A.R. Bhuiya is the senior counsel assisted by Ms. N. S. Law School. The IA has been filed seeking a change in the array of party respondents. The learned counsel for the applicant submits that they were under a mistaken belief that the respondents, appropriate respondents, were the director of elementary education. You had arrayed elementary.
Yes, at present, I am the elementary.
Elementary education. However, he subsequently being informed that the appropriate respondents would be. He had arrayed director of secondary education. And at present, subsequently he's been informed that the respondents, appropriate respondents, would be the secretary to the Government of Assam's Department of School Education,
Elementary.
and the director of elementary education, in place of the earlier respondents, which were arrayed in the accompanying writ petition being WPC 439 of 2020. Stop. Where a prayer made is not objected to by the learned standing counsel for education, MS NN Sarma. Considering the prayers made, the I stands allowed. The petition, the respondents, the Secretary, Government of Assam, Department of School Education, and the Director of Elementary Education are arrayed as party respondents 1 and 2 in place of negative. The I stands allowed. The Commissioner and Secretary to the Government of Assam Education Secondary Department and the Director of Secondary Education Department Assam, which were arrayed as respondents 1 and 2, are struck off from the array of the party respondents in WPC number so and so, and in their place, in terms of the prayers made in the IA, second Secretary to the Government of Assam Department of School Education and Director of Elementary Education Assam are arrayed as party respondents 1 and 2 respectively. In terms of the above order, I stands allowed, disposed of. Petitioner will file appropriate amended course title before the registry within 1 week from today. In the writ petition, you write in view of the earlier order, dated so and so, passed in IA number so and so. The Director School Education and Elementary Education are arrayed as respondent 1 and 2 in place of the earlier respondents. Petitioner will file amended course title within 1 week. Matter be listed thereafter.
Obliged. Thank you.
You will kindly pay us the last order, 19/6/2026. Petitioners have received the amount till date.
Lordship, we have submitted all the required documents on the 28/7/2025. The petitioner has filed writ petition praying for the same relief, Lordship.
Refund of what?
Refund of area.
Overdrawn salary, my lord, was
Lordship.
condoned there by my lords.
Huh?
There was an overdrawn salary to the
Overdrawn
tune of my lord, 1,44,000 something, my lord. And there were earlier around, my lords, there was a also direction to my lords to give me back, my lord, that money which I had deposited when I was confronted that I had overdrawn, my lord. I returned it back. Then, my lord, following the Rafiq Mas's principles, my lord, the court entertained and the court, honorable court said that return it back. So I couldn't file the contempt petition, but my lord, I have come with a fresh cause that because there was communication from their part that they will return the money, my lord.
Where is the direction of the court earlier?
My lord, kindly come to page number 45 minutes. There was a categorical, my lords, at page 46, my lord, there was the assurance, the written instruction there, right, my lords.
Yes.
Lordship, as the direction has been given on 1359/2023, the last in the last.
You file your
Lordship.
affidavit here and
Lordship, we will file Lordship.
Mr. D. Gogoi for the petitioner, NM Sharma for the secondary.
Secondary division, Lordship.
She is permitted 2 weeks' time to complete her instructions and file affidavit.
May I pray for fixed statement?
Released after 2 weeks. 26th of August.
All right.
No, six. These are all the compliance order. I have
Compliance.
given here, it affect.
Counsel for the respondent submits that the orders have been, directions contained in the order dated so and so have been complied with. Individual compliance orders have been issued.
Yes,
in respect of all the
29.
petitioners.
Yes.
And the same are placed before the court. Upon careful perusal, it is seen that the directions contained in the order dated so and so, passed in WP so and so, have been complied with by the orders dated 2/5/2026, passed by the respondent department in respect of all the petitioners. So, copy of the said orders have also been supplied to the counsel
Yes.
of the petitioner. Does not dispute the position on facts. In that view of the matter, since the directions have been complied with, contempt petition, the court does not wish to proceed with the contempt petition any further. According the contempt case number so and so stands closed, disposed. Notices if issued stand recalled.
And for the response.
Mr.
Okay.
SMT Chisti for the respondent.
Apply.
Kindly pass it over to the timing, it's the escort, it is on legs and code 4.
Yes. What is your instruction?
Instruction is Lordship, they do get a posting of husband and wife, but that would be an alternate. Not each time, it would be second time. So they are already availing the couple posting the present time. So the next time they are not. In what they are availing the couple.
No. You don't dispute the medical condition.
Medical condition.
So, in an individual case, if there is a requirement that medical condition requires alteration of the orders, the employer can't be so indifferent to its employees.
I would put this way, Lordship, the medical condition.
Or you extend her, she's praying for 45 days or something, you extend her.
Right. The medical condition does not suggest that she cannot move.
That's not for us to decide. there is a, you see, she was referred to GMC by the authority.
Yes, yes,
GMC says 45 days.
yes.
So you are not recalling this review order, this opinion. So therefore, either you have to say that no, this order, there is another view
The view of the medical board I have already.
that you have done, but medical board has referred, isn't it, to the GMC? Who has referred? Composite hospital has referred. They have given a report. Heard counsel for the parties, Dev Chaudhary, senior counsel, he is DI, for the respondent, assisted by Ms. S. Sharma, B. Sharma. The application has been filed seeking enlargement of time for a further period of 45 days to be stationed in Gauhati. Not as the petitioner's medical condition
Page 35.
as the petitioner's health condition in terms of the opinion given by the GMCH needs is required to be, she is required to take rest for 45 days because of general weakness and other medical issues which are reflected in the opinion prior to any decision to be taken for the applicant to proceed for intervention, medical intervention, which is surgery. Stop. The writ petition, the accompanying writ petition, the writ petition in which the IA has been filed, stood disposed of by direction dated
1/6/2026.
1/6/2026, whereby the
Page 22 and 23.
whereby the respondents were directed to accommodate the petitioner for a further period of 2 months, within which the petitioner was permitted to undergo surgical procedure if medically advised. Stop. Pursuant thereto, the applicant writ petitioner was examined by the composite hospital, and thereafter she was put up for an opinion before the GMCH, and the opinion of the GMCH is available at page 34, 35, the accompanying of the IA. So the opinion clearly reveals that petitioner needs to rest for 45 days. So on the earlier date, the respondents were, opposite party respondents were permitted to obtain instructions as to whether couple posting is permissible for the petitioner and her husband, as in terms of the present orders of posting, the petitioner is posted in Lucknow. Is it Lucknow?
Petitioner, lady is posted at Lucknow.
Lucknow, while her husband is posted at
Jalandhar.
Jalandhar. Stop. The learned DSDI submits that this couple posting is permissible under the rules for every alternate posting, inasmuch as the presently the petitioner and her husband are enjoying the benefit of couple posting and are posted in Gauhati. Therefore, they may be entitled for couple posting in the next alternative transfer and posting that may be called for. So, there are considering the submissions made and the materials before the court, and upon consideration of the medical opinion given by the GMCH, this court considers it appropriate to allow the IA by extending a further period of 45 days extending a period of 60 days to the petitioner for undergoing surgical procedure within the said period of time. Stop. I accordingly sends allowed disposed.
So,
Order to by the court.
This matter has been listed after a long time and I have also not action, so I will generate one with them so that I can take instruction and file the affidavit. Apparently,
What is your prayer?
yes, apparently,
Actually, my prayer is to get a grade pay of 9,400 like similarly situated assistant headmasters have got. So only that parity, and now I am retired, of course, but those benefits, if allowed, I'll get.
The respondents have not filed a counter affidavit on despite notices being issued in the matter as far back as 31/10/2022. So the respondents are therefore permitted 2 weeks' time and no further complete their instructions and file their affidavit for the court.
My lord, I'll pray for a date actually.
Release this matter again on 26th of August. Mr.
MK Chaudhary.
M.K. Chaudhary appears for the writ petition.
Well, in item number 26, the petitioners before your lordships are the two aspiring candidates of a selection process, the post of assistant professor at a certain such college in two departments, that is mathematics and chemistry of science stream.
Any counter affidavit to be filed?
College has filed an affidavit.
27 and 28 we have filed.
Your file, you're relying on the same.
27.
Is it is this affidavit good enough for item number 26 also?
No, because 26, that college part is
26, my lord, is slightly on a different footing.
Uh,
The interpretation of the order of this honorable court in item number, that is the 27, item number 27 by the college is the reason why we have come before this honorable court.
what is that order passed?
Your lordship will kindly see that order at page 31.
31.
Order dated 25/8/2023, wherein pursuant to the writ petition filed by the incumbents of that particular writ petition, there was an interim direction at page 33. Your lordship will see the last paragraph. In the interim, it is directed that 6 posts of assistant professors, that is 2 posts in zoology and 1 post each in botany, mathematics, chemistry, and physics shall not be filled up without the leave of this court pursuant to the advertisement dated 2/8/2023. Now, the advertisement were for 15 posts, madam. And we applied in the 2 petitioners were for 2 posts, 1 each in the Department of Mathematics and Chemistry. Now, the selection process was carried out, interview was held on 25/9/2023. And thereafter, when the outcome of this selection process was not revealed, we preferred a representation before the college authorities. And the college authorities came up with a reply. Now, your lordship will kindly see page number 30. Now, page number 30 is a reply by the college authority where they say, this is to inform you that due to Honorable Gauhati High Court's order, case number 4874/23, onward process for the said post has been put on hold till further notice. You will be informed accordingly in due course of time. That was on 29/12/2023. This reply was given. Now, my lord will kindly appreciate that the writ petition number 4874/2023 neither prays for stay of the complete the entire selection process, neither do they do they have the prayer for staying off the selection process in respect of the 15 numbers of posts. They are only concerned with those 6 numbers of posts. And we are not affected by those numbers of posts being for the time being put in interim. And even the outcome of this petition also won't affect us. We are only making a prayer that so far the selection process in regard to the posts other than those 6 numbered posts are concerned, that should be carried out, because already interview has been held and there is no legal embargo in terms of this order that the outcome of those posts cannot be declared, my lord. So that's why we are before this honorable court. And the college authority has filed an affidavit saying that they are also not averse to my prayer, but the only thing is that they perhaps need a clarification. So that clarification is given.
Affidavit filed where?
Yeah, in my writ petition.
There is no affidavit here. There is only your affidavit with regard to trustee.
But even
WBC 1212, item number.
WPC 1212.
No, that is not my. Oh yes, that is my case.
That is in that case I find my.
That is not here. When did you file it? No, but unless it is here, we are not accepting copies like that. When was it filed? It doesn't even know the date.
Lordship, I'm looking for 28. Also not received affidavit.
When did you file it?
My lord, that is filed in 2024, my lord.
Mr. D. Chakravarti, Learned Counsel, appears for the petitioner. Mr. A.Y. Chaudhary appears for
respondent number 3 and 4.
Respondent 3 and 4. Mr. A.R. Tovildar appears for respondent number
1 and 2.
1 and 2. Mr. Chaudhary, appearing for the college authority, submits that they have filed their affidavit as far back as 2024. So, however, the copy of the same is not available below the case record. Registry will trace out the affidavit stated to be filed by respondent 3 and 4.
Yes, 3.
And connect it to the case record. Release this matter after 2 weeks. And the rest of the matters?
Appearing for item number 27, madam. They have filed their affidavit in opposition. We haven't filed a reply. So I would like to file the reply, but the thing is, my lord, out here 6 petitioners are there, my lord. The first petitioner here till today, he has been working for 29 years, second 23, third 23, then fourth 21, 20, 17, man. For the past 29 to 17 years, all these petitioners has been working, my lord. And after the college, it opened for the science department in the year 1995. Then thereafter, this college came into the preview for provincialization when 2016 the whole exercise was done. But only on the ground saying that taking the because of section 3(1) that concurrence should be granted before 1/1/2026, and it cannot be granted after that with retrospective effect also, my lord. On that ground only, we have been denied provincialization then also, my lord, when the 2016 exercise was taken up.
You want to file a rejoinder?
I think it will be better, but otherwise also my second ground is that we have been working for the past 29 to 17 years, my lord, continuously. We are qualified, and I have given a tabulation of my this thing, qualification and everything. If your lordship will be kind enough to come to page 7, my lord, paragraph 4. The whole tabulation is there, my lord. And even the principal, they have supported our case and they have given representation to respondent number 1 and 2. They should be absorbed in this 15 sanction post, my lord. First one also on an erroneous understanding of the act, they have denied us. But second time we cannot be denied again, my lord. So lordship will kindly see that petitioner number 1, he was appointed in 1997, joined in 97. Second, 2003, joined in 2003. Then page number 8, my lord. Third, he 3 appointment, 3 he joined, 5, 5, 6, 6, 9, 9. So all of them have given continuously, and today also they are working, my lord, and they all are qualified. MSc, PhD, everything is there, and even the principal, everyone is supporting them. Then also they have said that cannot be absorbed, my lord. That cannot be a ground, my lord, and whether
where is their initial order of appointment?
Appointment, lordship will kindly come to. appointment annexure 1, page 27 to 32, my lord.
This was prior to provincialization.
Prior to provincialization. Thereafter, they took up the whole procedure for provincialization. Then
What is
they have given
what is
that
the procedure prescribed?
that concurrence should be there. They said ki when it was taken up in the year 2016, my lord, they said ki concurrence should be before given before 2006, my lord. If your lordship will come to annexure 5, page 47, my lord. Point number 3, my lord. Name of the college, MC Das College, District Kasar, my lord. So concurrence was given on 26 December 2008 with effect from 2003 and 4, my lord.
Yes,
Then they have filed the affidavit in opposition, my lord, and in the affidavit in opposition, they have said ki it's page number 76, my lord. You will come to page number 76. Paragraph 9, my lord. Okay. Second subpara. Should I show you also? The instant is assigned.
yes.
So on that ground only, they have
No,
denied.
please read 76. Which paragraph?
Paragraph subpara, my lord. In the instant case, the science stream of MC Das College was accorded government concurrence in the year 2008 retrospectively with effect from 2003 to 4 by order so and so dated 26/12/2008. So this 2008 is a problem, and as such the services of the petitioner cannot be provincialized under section 3(1) subclause 1 of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017 amended in 2018, and there is no other provision for absorption regularization of employees against newly sanctioned.
Which provision here?
Section 3 subclause 1 Roman 1. If your lordship will kindly take up the education manual, my lord, that is
Yes.
Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017.
Yes, section 3.
3 subclause 1 Roman 1.
Yes.
Provided, my lord, the second provided, not the first one, the second provided further that the order for such permission, recognition and concurrence shall have to be issued on or before 1/1/2006 and any other issued thereafter with any retrospective effect shall not be considered for the purpose of provincialization of services of any teacher and tutor as the case may be of the institution, my lord. So this ground they have taken, my lord, but this particular act, it was put into challenge before this honorable court, and a division bench of this court have decided this matter. They did not struck down this act as well as the Amendment Act of 2018. But regarding this particular point, my lord, I don't have the copy of the thing, my lord, but it was WPC number 2729 of 2019, and the judgment was passed on 4/12/2020.
What is the finding?
Finding in para number 160 and 161, they said, if the process of concurrence, if that has been started before 1/1/2006, my lord, so even if the concurrence is given after that, that would not kill what has been started before 1/1/2006. That's what the court has said. They didn't struck down this particular section, but they said ki if process of concurrence has been started before 1/1/2006, then it will continue even if the order is passed after 1/1/2006. That's what the court has said in para 160 and 160.
What is the case
That
number?
Case number is WPC number 2729 of 2019, a division bench of this court, my lord. It was heard on blank, man. It was a special bench. Justice Suman
Divided by, so decided on
4/10/2024.
4/10, 20?
4. And paragraph 160 and 161 refers to my case. So on that ground also, if the concurrence has been started before 1/1/2006, my lord, in the year 2016, when they took up the exercise of provincialization, that time also I have been denied. Then my second ground is, my lord, we have been working for more than 29 years. Some of the petitioners, like petitioner 1 has been working for 29 years. Then the second one 23, third one 23, fourth 21, 2017, my lord.
Yes.
Until today we are working and we are qualified. So how can
Respondent,
they not absorb
higher
us?
education or director, higher education.
Higher education.
You give us materials to show when did the process start? In terms of the judgment, firstly, do you agree with the submissions of the petitioner?
So I'll have to go through the judgment.
Please go through it. How is it that you have not gone through the judgment? You are a standing counsel. Such an important judgment. Heard Ms. Jane Moore, learned counsel for the petitioner, and Mr. A.R. Tovindar, standing counsel, higher education. Anyone else?
That is the principal of the college.
Who's for the college? Mr. A.Y. Chaudhary appears for the college. MC Das College, respondent number 5, has also respondent number 3. The petitioners before this court are lecturers. They're what, lecturers?
Yes.
Lecturers who are engaged in different branches, different subjects, being
The appointment is written as assistant professor.
assistant professors in the department of botany, mathematics, zoology, chemistry, again zoology and physics, respectively.
To zoology.
Petitioners were appointed initially by orders dated 18/7/1999,
97.
97,
It is number.
whereby they were appointed against non-sanctioned post of MC Das College
By the principal.
by the principal, which is with the due approval of the managing committee, governing body resolution, governing body. Stop. The petitioners fulfill all the criteria for being regularly appointed as assistant professors in the same college. So, since their date of appointment, it is submitted that since their date of appointment, they have been rendering their services. The present dispute before the court is the non-regularization of the services of the petitioners. Stop. By communication dated 26th of December 2008, the concurrence as is required to be granted in respect of the subjects was issued with effect from 2003 and 4 by the state communication. Stop. Subsequently, the respondent department rejected this concurrence granted in view of the second proviso, section 3(1).
1. Roman 1. 3(1). Roman 1.
It is 108.
Hmm?
It is 108.
108. This is Assam Education, Provincialization of Services, Teachers, Reorganization of Educational,
Institution
2017. Right, in our book it is 1990. As per the section 3.1, 3.1, then Roman 1. Second proviso to 3.1.1. The respondent department rejected the claims of the petitioners on the ground that the recognition and concurrence will have to be issued on or before 1/1/2006, and any order issued thereafter with retrospective effect shall not be considered for the purposes of provincialization of services of any teacher or tutor. So it is on this ground that the concurrence which was given earlier by the department by communication dated 26th of December 2008, accepted in favor of the petition. So the counsel for the petitioner submits that the recent judgment, where the virus of the statute was under challenge, in WPC number
729 of 2019.
729 of 2019, by judgment and order dated 4/10/2024, Division Bench Court, while declining to interfere with the statute, however, clarified in respect of section 3.1.1 second proviso that if the process of permission, recognition, and or concurrence in respect of under the provisions of the Act was initiated before 1/1/2006, although effective orders were passed after 1/1/2006, then such cases will be considered to have satisfied the criteria, satisfied the requirement of the second proviso of section 3.1.1. Stop. Under these circumstances, the petitioners are before this court, pressing the said judgment, submit that their cases are covered by the said judgment and the interpretation rendered, and therefore the petition should be allowed, and the petitioner's cases should be considered for due regularization in terms of the communication dated 26th of December 2008, whereby concurrence in respect of the subjects were granted with effect from 2003/2004. This is your case.
And the main ground is here, the advertisement is they have issued in the year 2023 regarding the 15 sanctioned posts. We have challenged that advertisement. We said it should be quashed and we should be absorbed.
The further challenge is to the advertisement dated 8/2023, issued by the college authorities in respect of the newly created posts of assistant professors. But this is for newly created posts.
So
in the post where you are working.
Lordship, in this, we are working, man.
No, you are working in the posts which are advertised.
No, we are not working in the, we started working in those posts which was not sanctioned before, man. But in the year 2000.
By way of the advertisement, certain posts are advertised.
Advertised.
Are these posts the posts where you are working, or these are separate posts?
These are not the posts we are working, but
you are apprehending that if the regular selection takes place, you will be
thrown out. So we said we should be absorbed in those posts. In the 15 posts, 6 of us should be absorbed. That's
the further grievance is the challenge made to the advertisement dated so and so, whereby 6 newly created posts of assistant professors in the science stream.
And this is 15 men.
Huh?
15 posts.
15 posts.
Yes, ma'am.
15 posts have been advertised. So the petitioners are apprehensive that if these regular posts are filled up, then the petitioners who are rendering services since 1997 will be released by the college authorities. So while issuing notice, this court had granted an interim order directing the respondents that 6 posts of assistant professors hyphen 2 posts in zoology, 1 post each in botany, mathematics, chemistry, and physics shall not be filled up without the leave of the court pursuant to the advertisement dated 2/8/2023. So this interim order still subsists, and the petitioners are also rendering services. So there are. Although notices in the matter was issued as far back as 25/8/23, the respondents have not filed any affidavit. Sorry, the college authorities have not filed any affidavit. The state has filed an affidavit on 5/8/2023, wherein at para 9, the position reflected in section 311 of the so-and-so Act of 2017 is referred to by the Director of Secondary Education, being the deponent, higher education.
And Lordship, it is also that there is no other provision for absorption, regularization, or employment against the sanction. That makes sense.
Is reflected by the Director of Higher Education, the affidavit filed. Stop. It is further, there is a further averment that there is no other provision on the Act of 2017 for absorption, regularization of the employees against newly sanctioned posts. Stop. However, there is no reference. The judgment pressed into service by the petitioner, which according to the petitioner has explained the provisions of section 3, second provision, section 311 of the Act of 2017. Era. The Learned Standing Council, Mr. Govindar, submits that he would like to complete his instructions in this respect. He prays for 2 weeks' time. Prayer made is not objected to by the council for the petitioner. The matter therefore be listed after 2 weeks. The college authorities are also permitted to file their counter affidavit if so advised in the meantime. Relist again on 24th of August. And it's also 24th, the other matter.
Lordship,
And what about 28?
we have not received any affidavit yet. That is
26, the order is saying we'll cover 28 also.
So there is an
Interim order passed, wherever passed, will continue.
in Lordship 28 is regarding the grade 4 and grade 3 employees, not assistant professor. 28. And Lordship, we have filed our affidavit.
No, you have not received affidavit filed by whom?
Without received, without
2028, right? Counsel for the petitioner submits that
Without serving-
affidavits stated to have been filed by the respondents have not been served on the petitioner. The counsel for the respondent will furnish an extra copy of the affidavit stated to have been filed. The petition counsel. Yes. Interim wherever passed will continue till the next date of listing.
I have also not received their full copy, my lord, the written actors. I have not received their filed by the petitioner of the respondent. Copies I have not received.
What? Who's in which rate petition?
Is just his affidavit. Which you have filed, but I have not received this one. And madam from them also, my lord.
The parties will exchange the pleadings. We'll exchange the pleadings, then serve copies on the respective counsel before the next date. Listing.
Okay.
File the affidavit.
So in this case, financial file the affidavit, but in our instruction, I have received that petitioner is not entitled for OPS loans. So that instruction I will bring on record by filing affidavit.
Petitioner is not entitled to
OPS loans, your old pension scheme.
bring it on record.
I'm not.
The respondents are permitted 2 weeks further time to file their affidavit. Mr. Deka, ABS for the petitioner. Relist again after 2 weeks.
Praying for OPS. This several dates have been taken by the government. And order dated 10/6/26 by Congress.
10/6/26.
Prior to that, several dates taken by the government for filing affidavit.
Yes.
Lordship said 10/6/26, they were to dispose of.
Yes, some process is going on, my lord. On my lord, when some process is going on.
What process?
My lord, here, my lord, Secretary of the Finance Department on 28/3/2025 issued a communication, my lord. Find out the persons who have joined the department on or, my lord, 1/2/2005. Process.
Earlier, same thing has been recorded, man. Lord, your Lord, what I pray, my Lord, since it is covered case, my Lord, Lordship disposed in the light of the common judgment passed by this.
Where is that?
The judgment is, my Lord, I'll take your Lordship to the facts. Advertisement was issued in the year 96, that your Lordship will get it on page 27.
Yes.
Then, my Lord, 98, the select list was prepared, that is at page 31. This petitioner's names are there. Then they were not appointed for whatever.
Who are the petitioners here?
Here they all this serial number 13, serial number 4, 10, 16,
4, 10, 16,
16, 13, my lord,
13,
18, 19,
18, 19.
and all others. I'll give provide a copy.
All right.
Then the court's order is there at page 36.
Court's order, 36. This is filed by whom?
Filed by the petitioners also, my lord.
For what purpose?
For the purpose of appointment, because they were selected.
But they were not appointed. They were not appointed.
Not appointed. So ultimately, the courts by an order dated 1/4/2008, page 37. Considering the matter in its entirety and in the interest of justice, it is hereby directed that the state respondent shall take necessary steps to issue appointment order in respect of the state 34 persons. So ultimately, my lord, they were appointed, page 38. 38 at a stipend of fixed pay of rupees 1,800. And the petitioners.
They are appointed as what?
At a fixed assistant teacher, at a fixed salary.
Assistant teachers.
At a fixed salary of rupees 1,800. And your lordship will get petitioners number at serial number 14, serial number 17, serial number 18, serial number 20, serial number 22, serial number 23, serial number 27, serial number 31, serial number 33, 33. So accordingly, my lord, copy of the appointments orders were issued, page 41.
They had given the undertaking.
Undertaking, my lord, it doesn't hold, my lord, your lordship.
But these appointment orders were passed on 2009.
Yes, 2009. But ultimately they were regularized. Regular scale, your lordship will get it at page 42. 41, 42. It's all regular scale of pay.
Okay.
They were regularized in the year 2011. And a copy of the pay grade was provided, page 43, 44. They were confirmed in service in 2018, page 45.
Then,
My lord, on this basis, my lord, your lordship will kindly see page 46. The judgment passed by your lordship, my lord, paragraph 23. Paragraph 5 I will read.
this is that where the process was initiated.
Yes, process was initiated in the year 1996, and not ultimately for whatever reason they were regularized in the year 2011. But
No,
so
but their
therefore-
initial appointment is in 2009.
2009.
But
it was for regular, for whatever reason they have paid this, it's a fixed pay only. So therefore, my lord, your lordship directed, held, my lord, para 23 is the relevant one of page 63, I think. 63, as discussed above, sorry, page 63, 62, para 23. In the facts of the present case, there is no dispute that when the advertisement was issued in the year 2003 and the selection process had commenced, the old pension scheme was in process. The judgment of the Delhi High Court and the Uttarakhand High Court were rendered on facts which are similar to the facts in the present case. The petitioners had also agitated their grievances by their representation dated 17 for the respondent authorities. The detailed representation preferred before the authorities, the petitioners refer to so and so judgment. Paragraph 24, as discussed above, the respondent authorities have not explained the delay of about 19 months which had occurred from May 23 to 24 for completion of the selection process and declaration of result. That apart, the appointment orders of the petitioners came to be finally issued on 2005. Such delay which had occurred during the selection process as well as the delay in issuing the appointment orders cannot be attributed to the petitioners in the absence of any explanations forthcoming from the respondent authority. The Delhi High Court had rendered several judgments allowing writ petitions where a person similarly situated as the present petitioners were granted the benefit of the old pension rules, two of which, namely so and so, have attained finality in view of the appeals preferred by the Union of India having been dismissed by the apex court. Under the circumstances, this court is persuaded to accept the views expressed in the judgment rendered by the Delhi High Court and Uttarakhand High Court. Accordingly, it is held that the case of the petitioner situated person ought to be converted under the old pension scheme. For the reasons held as said, we are not persuaded to accept the views expressed by the above which are relied upon by the respondents that the same are not applicable to the facts of the petition. Accordingly, petition is allowed by issuing mandamus to the respondents to treat the petitioners as members of the old pension scheme. Similarly, your lordship will kindly see page 161. 161 is more or less similar facts rendered by a single judge. 164, Vigol Kishore. Your lordship will get the facts at initially paragraph 2. The grievance of the petitioners, page 164, being ought to be addressed in this petition under 226 of the Constitution is that they pursuant to the advertisement in the year 96 issued by the Director of Secondary Educations for filling up 1,000 vacant posts of graduate teachers in high schools and madrasa schools of different district of Assam. The petitioners being qualified for same applied in the district of Morigaon. Thereafter, the respondent to have constituted district level committee in the year 1999 for conducting interview. The petitioners have participated in the aforementioned interview and thereafter, except the district of Morigaon, appointment of selected candidates was made in the year 98-99. Like but here in this case, the petitioners were selected, but no select list was published in the district of Morigaon. Thereafter, the petitioners herein have preferred to read petition being number so and so, and by an order dated passed in the aforementioned read petition, the respondent authorities were directed to pass appropriate order for approval of the select list, which was prepared in the month of March 2001 for the district of Morrigan. But by an order dated 2004, the respondent education department had held that the select list in respect of Morrigan district had already expired in 2001. The petitioners then approached this court by filing the WBC number so and so, and by the order dated 2009, this court was pleased to set aside the aforementioned order and directed to implement the earlier order dated so and so. Thereafter, the petitioners were appointed by the order dated 2011 as graduate teachers in different high schools, high secondary schools in Morrigan district, but they were denied the benefit of pension under the Assam Pension Service Pension Rule 1969. The court directed, my lord, ultimately, my lord, para para 1920.
What is
The
this?
result I
What
find
is this Purnima Hore judgment here?
that is that they are the stipendary teachers. They were appointed as stipendary teachers, and ultimately court directed that you provide them the old pension scheme. That your lordship will get relevant at page 80 to 92. Their Operation Blackboard teachers were denied, but the persons were appointed as stipendary teachers.
They were denied what?
Now, Operation Blackboard, there are 3 cases are there. This 4A case, my lord. Ultimately, your lordship will get it in page 80, my lord. 80. They are the stipendary teachers.
They were claiming the benefits of the old pension scheme. And our cases, lordship, that since their entry has been after the cutoff date, that is 1/2 of 2005, they will be governed by the new pension scheme. Now, regarding this, lordship, there was a detailed hearing. There, the lordship, these are some of these writ petitions that challenge the division bench also. It has been categorically stated that till date, only the stipendary teachers will be governed by the old pension scheme. No decision has been taken regarding the rights of any other teachers who have been appointed after the cutoff date, that is 1/2/2005, that they will be governed by the old pension. Now, main grievance of the petitioners are that they want to be governed by the old pension scheme. And regarding that, lordship, I have received my instructions. Lordship will allow me 7 days time. I'll file my affidavit. I've been inadvertently. I was not.
They have been taking time.
No, lordship. Within 7 days, I'll file.
And they are not distinguishing this case with the petitioner's case.
Yes. But no, but there is a division bench judgment.
Yes, lordship.
There, the principle laid down was that if the processes was initiated earlier,
Yes.
but for no fault of them, the matter got delayed.
Yes.
Where subsequent orders after the cutoff date
Yes, lordship.
will not disentitle them under the.
But lordship, here, lordship will appreciate that all these factors were considered, and then a decision was taken that only those who were appointed on stipendary basis, they will.
Who has taken that decision?
That was a judgment in Purnima Hore, lordship.
It was a single bench or a division bench?
That was single bench. Now that has been put to challenge. Not the stipendary teachers, but all the others. They were OBB.
What is the decision of the division bench?
That is still pending, lordship.
Still pending.
There was a.
That is a totally different case. That case, I'm also there, Mother. Here in this Purnima Hore case, 3 categories of cases. One is stipendary, another is Operation Blackboard, and another is drop teacher. So both held that the persons who were appointed as stipendary teachers whose advertisement was issued prior to 2005, they are entitled to get
Old
benefit of old pension scheme. Regarding OBB, I am there, I have also filed an appeal. OBB, they have denied on the ground that initial their appointments were under the operation, right, under a particular scheme, and subsequently they were regularized on the basis of the court's order. So that's a different category altogether. But after the judgment, my lord, this Jugal Kishore judgment has been passed. That is at page 161 by the London single judge. That 161.
Yes.
161. Same category, it was issued in the year 1996. Subsequently, they were appointed in the year 2011 on the basis of the High Court order.
No, so in Purnima Hore matter also, The stipendiary teachers were permitted because their appointments were made, their initiation was prior to
And Lordship, they had to undergo,
2005.
they had to
Sorry.
undergo some training, which they had to undergo some training.
No, those are the requirements of under the Act. The question before this court now is whether they're entitled to the earlier pension.
Yes, Lordship, that has to be decided.
At a point where their initiation for appointment was done well prior to that.
Lordship.
However, their appointments were done after the cutoff date.
Yes. Lordship.
No explanation as to why the delay is occurred.
In the case of the stipendary teachers, they were supposed to undergo some training which was be undertaken by the government, which was not taken, because of which they were given the special consideration. Apart from that, Lordship, the other batches, they were, Lordship has, my learned senior has pointed out, there was access teachers also, there were more categories. There was access teachers, there were teachers who were from the autonomous councils also. So all these batches were decided, and it was decided that they won't be entitled. Then
why were they not entitled? What is the rationale?
Lordship, that has been discussed in the Purnima or in judgment.
So we want to know, tell us, what is it?
Lordship, here, Lordship will allow me to file my affidavit on the basis of my affidavit. I'm just seeking 1 week's time, Lordship. Within 1 week, I'll.
They keep seeking time since 2001, my lord. 24, my lord. They're seeking time.
Within 1 week, I'll be filing my affidavit.
Your lordship has heard the matter, my lord. Your lordship.
Yes, Lordship will list the matter next week. I will file it within 1 week.
No, but to what effect are you filing your affidavit?
Lordship, because they are appointed, they are considered as fresh appointments.
Why?
As well. Because Lordship, here also in the judgment, Lordship, here we if Lordship will come to.
No. This initial appointment was done by way of the advertisement. This was initiated when?
Initiated in 96, man.
96.
Select list was in 98.
Then thereafter there was a judgment of the court.
Yes. Judgment of the court is at page, my lord, 32 euros.
Now between 98 and 2006, is there anything that happened which disentitles the petitioners?
Lordship, I will just pray for 1 week's accommodation.
No, we'll give you 1 week,
Yes.
we'll give you 2 weeks, but we want your affidavit to clarify
Yes.
that in page 31, there is an order of, there is the select list.
Yes.
23/11/98.
Yes.
The select list follows the advertisement which was issued.
Yes.
Which means that the government was desirous of making appointments to
Yes.
certain posts, to which the petitioners applied. They were selected. Then they were not appointed. Now, is it a case that the appointment process was dropped, rejected?
Yes.
There was some litigation. What was the process? Thereafter, there was a direction by the court to appoint them. Subsequent thereto, they were appointed. So, if the petitioners were selected on 98, and if the process would have regularly taken place, they would have been appointed well prior to 2005.
Yes. That is their Lordship. So, here, Lordship,
So that is the clarification, you bring it on record. Yes, Mr. Das will give them 2 weeks.
Your lordship heard
one last.
Your lordship has heard the matter.
We'll hear it again if required.
Yes, Lordship is there, but Lordship has got one last
We
opportunity.
are responsible to
May
my
record
record. So many dates have been taken.
One last
Ultimate date
1
is
week.
there.
We'll give you 1 week to file.
Lordship, one last opportunity. Yes. We'll find it.
Third, Mr. B.D. Das, Learner Senior Counsel, assisted by Ms. Harding. Learner Counsel for the petitioner, Mr. P.K. Bora, for the secondary education, elementary. And Mr. A. Chaliha appearing for the finance department. The petitioner's grievance that they are not considered eligible for grant of pension under the old pension scheme, notwithstanding that they were selected by, their names appeared in the select list dated 23/11/98, and had the process of appointment been carried out by the respondent department, in right earnest, petitioners would have been appointed well prior to the cutoff date for, well prior to the incorporation of the new pension scheme. So, the respondent status, you have not filed an affidavit. The respondents have not filed any affidavit. Considering the issues involved, the court permits the respondents 1 week's time to file their affidavit. Release again on 25th of August.
No further time. We must respect the system.
The court, if the affidavits are not filed, court will proceed to dispose of the matter on the materials available.
Right. This is related to non-payment of family pension. As per scheme, the petitioner husband died in harness and he is entitled to for family pension under the 2017 scheme. But the respondent have not taken any step to release those pension benefit to the petitioner. Moreover, during the lifetime of the petitioner husband, he deposited some amount of the amount in his GPF account. That also had not been released till date. That is.
Yes, respondent.
Hello, your lordship. I have received some instruction. As per this instruction, madam, the personal EO has informed that the petitioner has not submitted the relevant documentary evidences in connection of GPF account, madam. So sometime you may allow madam proper instruction from about the
What documents are required?
Document is at their place. GPF amount they have to giving the report.
How much time you want?
next Monday.
Next Monday. Next Monday.
Madam.
It's coming Monday. On the request of the council. Which department is this?
Elementary, madam.
Elementary education.
Otherwise,
Then
Wednesday.
instructions are not complete. She submits that the matter be relisted again on 12th.
Madam.
12th of August. It's the people were and then council appears for the petition. It's on 12th.
Madam.
Any filed affidavit?
Not filed yet.
Do you intend to?
Yes, madam.
How long will you take?
3 weeks, madam.
2 weeks. Mr. A.R. Mia, Senior Counsel, assisted by Mr. H. Ali, Commissioner, Mr. N.J. Kadonier, S. Losco. Mr. N.J. Kadonier appears for the elementary education. He is permitted 2 weeks further time to file the affidavit as prayed for. Mr. Ali appears for item number WPC so and so similar orders. MS Bora Hazorika. N Hazorika for finance. For SSA.
Obliged.
Released after 2 weeks. Yes.
Therefore, lordship, reinstatement lordship, I was from 25 to 2025. And also my department proceeding
State
Why have you filed an IA?
or reinstate stay of the suspension order.
Third counsel to the parties issue notice of the IA. Returnable 2 weeks. The Mr. N.J. Katonia, standing counsel, appears for all the respondents. You're for elementary as well as Department of School Education.
Yes.
For all the respondents, there were notices of waived, extra copies will be furnished in a period of 1 week. Respondents may file their objections if any. Matter be listed immediately after 2 weeks.
The petitioner completed 30 years of service and he retired. Without my lord giving any benefit under MSCPS scheme because no promotion was given to him. He was a grateful employee. This was issued.
Under which department?
Education department is inspector under inspector of school.
The respondents will file their affidavit in the matter, explaining as to why the claims of the petitioner relating to MSCPS during his service period, service tenure was not granted. 2 weeks further time is granted to the respondents to file their affidavit, in which consequential orders may be passed by the court. It is submitted that the writ petitioner is already superannuated. Released again after 2 weeks. 24th August.
In this case, my lord, they have filed today one affidavit, but I think, my lord, they have not addressed entire issue. Not in this case is pertaining to the special school.
You file your review reply.
Yes, I shall file reply on special school, my lord. In these the 3 schools, my lord, there is no teachers. There is no infrastructure, my lord. In spite of grant of 13 crores per year, this time also around 13 crores have been grant sanctioned in the budget, my lord, for the 3 numbers of special school investigators. And there,
Mr. B. Pulkester for the petitioner, Ms. P. Chakravarti, learned standing counsel, social justice and empowerment, and MS N. Sharma, A. Sharma for the accountant general. MS Chakravarti submits that an affidavit has been filed today. So the same, however, therefore is not connected to the case record. Matter be listed after 1 week.
and date may be now.
How much time you want for reply?
I thought 1 week, my lord.
1 week. Registry will trace out the affidavit stated to be filed with the respondent and connect same to the case record. The petitioners are also permitted to file their rejoinder pre-list on 19th August.
Matter relates to non-payment of the regular scale of pay from 1/3/1999 till 1/7/2019 to the petitioner. The benefit of which has been given to the other civil person. Not considering the petitioner's case is that he has not filed a requisition. The other persons have filed requisition on the basis of requisition order. Benefit has been given.
Where is the order?
That order is that lordship at page
114.
yes, lordship. The 99 lordship.
So the
99
operative.
is the High Court order.
No, what is that 114?
114 is the secretary's order lordship.
No, 114 is the.
114 decree.
The High Court order is at 99.
99. By that order, the dishonorable court directed the respondent to consider the case of the petitioner. So again,
Yes. Respondent.
Yes, my lord. Instruction is awaiting, my lord. Interdepartmental communication is going on, my lord. So sometime may be granted here, my lord. Because the petitioner was earlier appointed in ad hoc basis.
She was appointed as what? Hindi?
Hindi.
So earlier 500 teachers were appointed under the centrally sponsored scheme. So that was abolished in view of non-providing the fund by the central government. Thereafter, the state government took up the issue and 401 posts were created and intended to regularize the said post. So thereafter, 82 posts has not been regularized on the ground that the persons were appointed in the ad hoc school. So subsequently, they preferred repetition before this honorable court, and this honorable court directed to consider case sympathetically. So thereafter, all of them were regularized in 2019. But from the date of 2009, they are given regular scale of pay. So therefore, the other similarly situated persons filed 2 batches of repetition. Ultimately, this order at 99 has been passed, whereby this honorable court directed to consider a case of the petitioner. So on the basis of this order, that is at page 116, Lordship, the secretary has given benefit to those who has filed a petition. Petitioner was at that time under the impression that the association was fighting for all the 82 teachers. So therefore, she has not filed any separate petition. So after having to come to know about the order, she filed a representation, and a report was also called from the director has called for a report from the circle, inspector of schools. The report is also at page 126.
Do you file the affidavit? Otherwise,
Thought that at the verge of retirement.
oh. Mr. S. Deka for the petitioner, Mr. U. Sharma for the secondary education. Mr. Sharma submits that 2 weeks further time be granted to file his affidavit. Prayer made is allowed, released again after 2 weeks.
Date may
24th August.
20. Apply.
Imagine, as per my last order, there was, they have stated that there will be a state level meeting.
Verification on 13/8 month. Document verification scheduled on 10/8. Directly. Then there's it from me.
A copy of the same may be provided to us.
The petitioner here, both.
No, madam. Serial number 2.
So let us see what happens on 39.
It may be posted after.
Third council parties, as per the instructions received from the studying council elementary education. The Joint Director, Secondary, what is this? Elementary Education, has issued a communication to be conveyed to the petitioner to be present for verification of documents on 13/8/2026 at 11 a.m. in the office of the District Elementary Education Officer, Assam. Stop. The following documents are required to be brought by the petitioner and the other candidates who are called for by this letter for document verification. It will give you. The such circumstances, counsel for the parties submit that the matter be deferred to be listed after 13th. Let it come in September. Release this matter again on 2nd of September.
Kindly take the last order. Find our activity. Long-term and audit report.
What audit report? When are you likely to receive? None appears for the petitioner.
Next time we can.
Mr. P.K. Bora, standing counsel, submits that the audit report directed to be affidavit filed.
Not man.
Huh? Huh?
Not fine. Here, man,
This is a very casual attitude. You see, the order says that the standing counsel undertakes that an affidavit is to be filed. You have failed on the undertaking. It's contempt. Look into the provisions.
One week time may be granted.
Despite the order dated 24/6/2026, the standing counsel, elementary education, failed to file the affidavit as directed. Further 2 weeks' time is prayed for on the ground that the audit report has not been received. Considering the prayer made, matter be relisted again after 2 weeks on 24th of August. Affidavit be filed. Affidavit be filed or before 24th. Cost of ₹3,000 imposed on the department to be deposited before the next date of listing.
Last order
We deposited the Gauhati High Court services. Yes.
order dated 22/6/2026. Direction. I have submitted the certified copy.
This is the instruction that I have. Calculation for the area is processed and the kitchen then once just now I have received.
principal of the college already sent the proposal by calculating the my lord area salary. I connect the my lord.
How long will it take? There's no indication of any dates.
That's it. Okay, does it make it 3 weeks time? I
On the instructions, the Standing Council Higher Education submits that the proposal for area salary of the writ petitioner is presently before the auditor and the directorate of higher education for verification. After completion of verification, if the petitioner is found to be entitled for area salary as per rule, same will be sent for approval before the appropriate authority. Let the verification be undertaken within 2 weeks. Thereafter, if the petitioner is found to be eligible, the proposal for release of area salary sent by the department within 3 weeks, within 2 weeks thereafter. Release the matter after 4 weeks.
yes, so he said that specific direction.
7th September.
All right. Case for notice was issued on 8/4/2026. No affidavit has been filed. The second round of litigation, earlier, this honorable court directed to provincialize the service of the petitioner. Subsequently, kindly see page 81. The government returned the case of the petitioner for filing review and appeal, but no appeal, no review has been filed.
Why file contempt?
But it is the order of 23, 21/3/23.
Then what can be done? You slip over the matter. Already there is a writ.
Wait, my lord.
Repeated writs. Why should it be issued?
The order was passed on 21/3/2023, my lord. And
You did not enforce you have the remedy before you. The respondents will file their affidavit, further 4 weeks time granted. Release this matter again after 4 weeks. Mr. K.R. Patgiri appears for the writ petitioner. Mr. P.K. Bora for the respondent.
Lordship, this matter pertains to Great Pay, Lordship. The petitioners herein are the
This respondent, which department is this? Secondary education is permitted 4 weeks further time to file their affidavit. Mr.
PDAS.
Pidas appears for the writ petitioner. Released again after 4 weeks.
Much obliged.
Please, Lordship, this matter may be taken up after some time. Senior is on log. My senior is on legs in other two.
Who is your senior?
Yami Mahmood.
Yes, what is the matter?
My lord, regarding my lord family pension between 2 years, I am the first wife.
There is already a judgment. Why are you repeatedly coming before the court?
There is another issue.
What is that?
Now, my lord, they have come up with stand that, my lord, I am divorced. But that divorce, my lord, that has thereafter even compromise took place, my lord. I was given maintenance, my lord. I am all along with my husband, my lord, till his death, my lord. Voter list, Aadhaar card, PAN card, every record, even in the death certificate, my name appeared as first wife.
What is the finding of the full bench?
Finding of the full bench, my lord, that was regarding, my lord, in, my lord, Junufa BB, my lord, 2023 1 GLT. That is, my lord, the first wife will receive, my lord. And then, my lord,
So who is the first wife here?
I am first wife. The only issue, my lord, that they have brought, my lord, before this honorable court, that is only that I am divorced. But that is not correct, my lord. I have every document. And, my lord, two judgments, my lord, passed by this honorable high court, my lord, said that, my lord, there should be two arbiters, one from husband side, the other one from wife side, and they will try for reconciliation. When the two arbiters say that the reconciliation is not possible, my lord, then the talak or divorce, my lord, is effected. So that thing, my lord, that is not followed up in this. And, my lord, this is not talak, my lord. Now, as per the full bench judgment, my lord, my name should have been, my lord, recorded as nominee. The only strength of the respondent number 9 that on the strength of nomination, my lord, she is receiving the family pension, my lord. I'm the first wife. I have built up the family, my lord. I have constructed the family. And now, my lord, I am deprived.
Yes, who's for the state?
Then judgment also by this
Elementary education. Who's for the state? The judgment is already there. Why is it not sorted out like that? Why another order is required? Junufa BB,
Yes, ma'am.
you examine and come back next week.
Yes, ma'am.
The issues raised before the court in the present proceedings pertain to share of pension between two widows of a government servant. A full bench of this court in Junufa BB reported in so and so has laid down the provisions as to how the pensionary benefits are to be, as to how the claimants will be governed by in respect of their claims for pension. So, counsel for the respondent will apprise the court as to what steps have been taken by the department to redress the grievances of the writ petitioner vis-a-vis the claims made by the private respondent. List on 21st August. Mr. A.F. Mullah appears for the petitioner. N.J. Khatoniar for secondary education. Bora Hazarika. Your Hazarika. S. Sharma for Accountant General. On behalf of Mr. B. Sharma. Your name? A. Hussain on behalf of M. Sharma, on behalf of Respondent 8. Mr. So-and-so on behalf of Respondent number 9. Mr. Pegu on behalf of Respondent 2 and 5.
I am for elementary education.
Yes, elementary N.J. Khatoni. Released again on 21st.
I submitted a representation also, but director has allowed pension in her favor. Only on the strength of nomination.
Pension is allowed.
Pension allowed, she is
Is
receiving.
there a stay?
Since, no, there is no stay. Because, my lord, I could not show the nomination. Court wanted to see the nomination. And that was made behind my back, my lord. By the husband.
We'll consider on the next day.
Deeply obliged to me.
From last preparation also, she had issued some, they were supposed to get some instruction on my additional affidavit that whether they are implementing the proposal, which has already been approved by them, which is at page 101 of my additional affidavit. But no affidavit has been filed even as of today. The last 2 years, my lord, petitioners are before your lordship, and four of them are on the verge of retirement.
Yes,
As regards the implementation of this decision, madam, that sort for list of employees were appointed after 1/2005, but their recruitment process was begun before that, madam. That list was for the government, madam. Thereafter, madam, no decision has been taken.
But I have no instruction, Malad, whether this kind of exercise was taken.
Yes, madam. In fact, I have the list for the Morigao district, total number 193 teachers. They were appointed after 1/2005.
no, the question is not when they're appointed. If they're appointed earlier, they would not be here.
Yes, yes. That's there.
The issue is that whether the process was initiated prior to one.
Process here is 1996. At
One
least.
125.
There is no dispute on that, madam. It was initiated prior to 1/2005, and they were
You
appointed.
belong to which district?
Morigao district.
Morigao district.
Morigao.
Morigao, I have got the question, madam, that altogether 193 teachers are there. Thereafter, madam, what happened? There are
193?
teachers, similarly situated teachers that were appointed pursuant to 1/2005, madam. After one.
No, they were appointed, but when did the process, when was the process initiated?
It was initiated in the year 96. Advertisement was published 96.
Then they're entitled.
That aspect, madam, there was no dispute, madam. Pursuant to the decision of the Honorable Court, madam, they were appointed in the year 2014.
Where is the order of the court? Which order of the court?
Malad, last order was on 17/7/26.
No, there is some earlier order of the court referred to.
Yes, madam. 5/9.
You are praying for a pension.
Page
Yes,
40, madam. Page 40.
The old pension scheme.
Page 40, annex 4, madam.
And page 40 is the judgment, Malad, pursuant to which we were appointed, Malad. The select list of 35 candidates as regards Morigao district was held to be correct, Malad, by the division bench, and thereafter the matter was taken to the Supreme Court. Supreme Court also didn't interfere, and therefore, Malad, these present petitioners were appointed pursuant to that select list. That select list was declared to be valid. No dispute that they were their selection process was initiated in 1996. There is no dispute, Manoj, regarding their appointment thereafter in the year. Manoj. And 2016, they were given regular time scale of pay. And since then, they were getting the regular time scale of pay. So now in all other districts, pursuant to these advertisement, Manoj, other districts appointments were made only for as regards Morigao district, some dispute arose, and therefore it was due to the litigations, Manoj.
Are you relying on any authorities in support of your contention?
Manoj, in fact, today I got to know about one judgment I'd like to rely on. It comes next week. That judgment also.
Counsel for the petitioner submit that she would like to rely on certain judgments, support of her contentions, prays for a week's time. Release this matter again after a week. Still, J. Katonia appears for the respondent. After 1 week. Want a date?
Yes, ma'am.
17th.
Judgment, minority division bench judgment. See.
Whatever.
Fine.
None appears, the matter is called up, released after 1.
Lordship, your Lordship, reading the last order, the respondents had stated that they were to bring instructions with this regard.
Well, this matter may be taken up along with petition number 3521 of the 2024. Here we have filed an affidavit which will cover this.
Where is that matter listed?
That my lord. After 2 weeks,
Have you served the copy?
I'll serve, my lord. I'll serve on it. 3521.
Counsel for the respondent submits that there is another matter where similar issues are raised, being WPC number
3521 2020.
3521 2024. It is submitted that an affidavit has been filed in the matter, and the department would like to rely on the said affidavit in respect of the present writ petitions. Stop. He therefore submits that these writ petitions be listed along with WPC
3521
of 2025. 2024. Stop. Since the affidavit filed in that matter is sought to be relied on by the respondents, copies thereof be served on the writ petitioners in the present proceedings, and the petitioners are also permitted liberty to file their reply if so advised. Released again after 3 weeks.
Okay.
Lordship, the matter refers to the mediation lordship already been settled, lordship.
Settled.
Settled, lordship. And the
Agreement executed.
yes, lordship.
Where is that?
That's flag mark. Condition is petitioner will get 70%, and the row 8 will get 30%.
Agreement is not here. They brought on record.
On the next page.
Huh?
That office note, after the office note.
After the office report. Heard counsel for parties, the matter was referred to mediation. The learned mediator, by the report dated 19/6,
Sorry, 19.
19/6/2026, has placed the report that the matter has been settled on the following terms and conditions. Terms and conditions. The writ petition therefore stands closed in terms of the agreement and settlement arrived at by and between the parties.
One thing, lordship, and the is referred to the accountant general for needful receive respondent. Option.
The official respondent will do the needful in terms of the agreement arrived at by the respondent.
Obliged. Challenges of him as a principal of the college, long pending matter, respondents have not filed any reply.
Where is the order of suspension?
Page 35.
Who's 6 and 7?
According to
Where is the suspension order?
page 35.
35.
35.
You have entered appearance today. What what do you have to say?
This order earlier passed, Milord, that was revoked by the director by an order, and only that when the order was passed, Milord, on the same day governing body raised objection and they referred the matter to the again to the director, and director passed an order in terms of that objections.
Where are the objections? Anywhere?
It's there, Milord. Page 37. 44 was the order revoking the earlier order. Your should be check page 36. Persons on the demand, department based on the suspension by the order is ever reinstated. That is page 36. Reinstated. That is 44 million. And only 44 knowing about this order, the governing body made this objection, and on the basis of that, steps were taken by the director, and on 10-5 again, 10. Again, initiated inquiry on those allegations.
What has happened to the proceedings? Who's for the department?
Should we grant us 2 weeks time to complete our instructions? Instructions.
Right matter below.
Why do you want 2 weeks to get the instructions? What has happened to the proceedings?
Short date maybe then a week will be.
Let us have it after 1 week with the instructions. What has happened?
Yes.
Mr. D.P. Chalia, Senior Counsel, assisted by Ms. M. Roy, the petitioner, and Ms.
P. Upadhyay.
P. Upadhyay appears
Mr. D. Upadhyay.
on behalf of Mr. D. Upamenyu, appearing for the Department of Higher Education, as also Mr. appearing for respondents 6 and 7. The petitioner is aggrieved that by virtue of the order dated
10-4-25, page 15. 10-4-25 million. Next suspension was on 10-4.
10-4.
At page 58.
58.
At page 58.
So earlier page 35 was revoked.
It was revoked by themselves, Milord. And on the same day they raised these objections. And after that, Milord, on 10-4 this order was passed.
Was placed under suspension earlier on what is the date of this order at 35?
18-9, Milord.
15-9.
18-9.
18-9.
18-9, earlier order.
No, 18-9 he was detained.
On that day itself.
On the date of arrest.
Date of arrest, he was under suspension.
This was order was issued. Subsequently, the same was revoked. However, on a complaint raised by the governing body of the college, the subsequent order of suspension was issued on 10th of April 2025. Petitioner was suspended under Rule 6 within bracket 1, bracket close, bracket small a of the Assam Services Discipline and Appeal Rules 1964. Stop. Since then, the petitioner has been under suspension. An inquiry appears to have been conducted against the writ petitioner, but whether the same was concluded is not available before the court. The respondents are permitted 1 week's time to apprise the court with regard to the departmental proceedings initiated against the writ petitioner and the status thereof. So, let this information be placed before the court by the next returnable date on 21st August, released on 21st. Yes.
Yeah, I'm for the item number 53, item number 4, connected matter. But leaving our much let this mode, second half of it. So, I pay for there was meta for disposal. I pay for 115 August disposal.
Yes.
Otherwise, I have some urgency because the pendency of these cases, my pension has not been finalized.
What is the issue here?
The petitioner in I think 54 was selected and appointed as principal of a high secondary school. My selection was challenged by him, in that challenge, my appointment was set aside by reasonable court, remanding back the matter to the authority. On remand, in the meantime, I also prepared a review. During pendency of the review petition, the remand order was complied. They have held that I was the first candidate in the select list. Pursuant to that, remand order, I should have been reappointed as principal. But in the meantime, I retired from my service. Now, neither I was appointed as principal nor my pension has been finalized. As the selection has been redone, and I was entitled to be appointed as principal, I should have been appointed before my retirement.
So let it be taken up together because it's one is challenging the other's orders. When do you want it? 18th. The matters be listed for 18th as prayed for by the council notification. Joint prayer. Mr. Goswami for appears for respondent number 5. Mr. Dotto for 1 to 4. Higher education, secondary. Secondary education. Mr. I.H. Sokia appears in item 54. Mr. Bora in item number 53. List on 18. Endeavor should be made to dispose of the matter on the next date of listing.
Hello, please.
For hearing item 55.
Your lordship, if your lordship to hear the part of the amicus on another date, says having some personal difficulty.